Okay, we're back. Chapter 15. We're on bankruptcy still, and we finished the part of bankruptcy with regard to Chapter 7, a straight bankruptcy. Now we're going to talk about the types of reorganization. I'm not going to go into a lot of depth on these because they're all similar. The goal is similar. The goal is to allow the debtor to keep property and to repay their debt either in whole or in part, but over a longer period of time. The advantage here is that the creditors get something and the debtor gets something, and it's not an all or nothing thing. So here the creditors and the debtor formulate a plan under which the debtor pays a portion of the debts and is discharged of the remainder. The debtor can remain in business if it's a business reorganization. So in this situation, when the debtor files a plan suggesting to the court how they're going to pay their debts, who's going to get paid how much, and how it's going to work. Anybody who's eligible for Chapter 7 other than a stockbroker or commodities broker can file for relief under Chapter 11. Railroads are also eligible. There's a fast track for small businesses. The same principles that apply to 7 apply to 11 proceedings, and it can be either voluntary or involuntary. The automatic stay provisions apply, and so do the exceptions. Workouts are a way of avoiding a Chapter 11 bankruptcy. It's an informal process between the creditors and the debtors to adjust the debts of the debtor. They're less costly and usually more flexible. So debtors and creditors are encouraged to work out, to put into effect workouts. A debtor in possession, a DIP, the debtor in one of these reorganizations is allowed to keep in their possession property to operate their business as it says. Or the court can appoint someone, a trustee called a receiver, to operate the business during the course of the bankruptcy. Okay, so the plan has to be fair and equitable to all parties, and it has to do these things as designated by the bullets on the slide. It has to designate the classes and claims and interests of the creditors, specify the treatment to be afforded to each class, provide an adequate means for the plan's execution, provide for payment of tax claims over a 5-year period. Alright, so once the plan's been developed, it has to be accepted. So it's submitted to each class of creditors for acceptance. Each class has to accept in order for it to be adopted. The majority of the people in the class vote to approve it. If it's approved and if the debtor completes the plan, then the debtor receives a discharge upon completion of the plan. The confirmation of the plan, though, does not create a discharge. So it works the same as a 7. The debtor is protected from future lawsuits and claims. Okay, Chapter 12 is a reorganization for farmers and fishermen. Basically, these statutes were created back in the 80s, I believe it was, when there was a huge amount of foreclosures on family farmers and fishermen due to the economy. A lot of historians would blame the farmers' foreclosures on the federal government which encouraged people to take out loans through the federal government to expand their farming operations, and those did not work, and it ended up with farmers being in debt. To save the family farm, Congress adopted chapters 12. 12 and 13 are very similar. 13 is used by individuals. Again, they're also like 11 in that you file a plan. The plan has to be approved by all the different levels of creditors. So under 13, individuals with regular income who owe a fixed liquidated unsecured debts of less than $383,175 or fixed debts of less than $1,149,525 use the Chapter 13 process. Partnerships and corporations are excluded. Notice it says regular income. That does not have to be wages, okay? It can be a trust, it can be Social Security, it could be a pension. As long as you have income enough to pay off your debts under the plan, then it meets the requirement of regular income. Okay, filing the petition. So you can be initiated by the debtor filing a petition or by a court ordering a conversion from a 7 to a Chapter 13 because of the bad faith or other reasons under Chapter 7. The court appoints a trustee. The trustee is the person who takes in assets, pays off creditors under the plan. The automatic stay takes effect. There's a good faith requirement on the debtor at the time of the filing of the petition and the plan. So here's what the plan has to do. The future earnings of the debtor are turned over to the trustee so the trustee can pay under the plan and make sure everything is paid off. There's a certain amount, though, that does go to the debtor for the debtor's immediate needs. Full payment through deferred cash payments of all priority claims, such as taxes. Identical treatment of all claims within a particular class. As I said before, one of the unique provisions is that the plan can require the debtor to pay a debt in full, or it can compromise the debt and pay a lesser amount. The debtor has to begin making these payments through the trustee within 30 days after the plan has been filed and must continue to make timely payments. Allowable expenses. This is for the debtor. A debtor must apply the means test to identify the amount of disposable income that will be available to repay creditors. The length of the plan can be 3 or 5 years, depending on the family's income, but cannot exceed 5 years. The plan has to be confirmed by the court, which holds a hearing and allows any interested parties to attend and object. And the court's going to confirm the plan under the following circumstances. If the secured creditors have accepted the plan, if the plan provides that the secured creditors retain their liens until there is payment in full or until the debtor receives a discharge, if the debtor surrenders the property securing the claims to the creditors. So what about discharge in this process? After the debtor has completed all payments, then they can be granted discharge, except claims that were not allowed by the plan, certain long-term debts provided for under the plan, certain tax claims and payments on retirement accounts, claims for domestic support obligations, debts related to injury or property damage while driving under the influence. So this order granting discharge is final as to all the debts listed in the repayment plan. Okay, so we talked about family farmers and fishermen. I'm not going to talk much more about them. A family farmer is one whose gross income is at least 50% of farm dependent. This is because there are some people who have farms but also have jobs. So we have to define who a farmer is going to be under Chapter 12. The total debt can't exceed this $4 million plus. A family fisherman, you see the same kinds of rules apply to the definition of a family fisherman. The debtor files under Chapter 12 and must file a plan no later than 90 days after the relief has been entered. That is a stay. Okay. So the rest of this is pretty similar to Chapter 13 with some minor adjustments. I'll let you look at the slides and at the textbook on those. Again, there's a confirmation of the plan, and that is basically Chapter 12. Okay, so that ends Chapter 15 of the textbook. And again, the magic word for Chapter 15 is bankruptcy. I hope to see you again on Chapter 16.